Good day, Crime Talk aficionados. We have a great show for you today. The key witness in the Bryan Kohberger murder trial repeats testimony claims in police footage to not one, but multiple officers. Did the government's case against Sean Diddy It Combs crumble quicker than a freak-off fiasco? The defense is not happy in the Luigi Mangoni case. Lori Vallow gives the judge a list of her grievances. Karmelo Anthony, remember that kid? Yep, he's been indicted. The feds get a hate crime conviction this day in legal history. Our legal quote has to deal with free speech. And the Dumb Criminal of the Day award goes to Charles Dazell. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications of when we go live or put up new content, and yes, check us out on any of your favorite podcasting apps. Now, before we get started, I'm going to remind you, go to crimetalksearch.com and sign up for that background subscription service today. When you do, you'll be able to do as many background searches as you desire. And that report is literally prepared to you while you wait, and it's going to have all types of information that you're looking for. Phone numbers, email addresses, social media presence, whether somebody owns property, are they married, are they divorced, do they have a criminal history, are they on a sex offender registry? Go to crimetalksearch.com. If there's somebody coming into your life, or maybe you're just not getting that warm, fuzzy feeling that maybe they need to be out of your life, go to crimetalksearch.com. Put those concerns to rest. All right, let's go ahead and open the record for Wednesday, June 25th, 2025. And first on the docket, Bryan Kohberger. Police body cam and dash cam footage from the September 2024 traffic stop in Pullman, Washington, has revealed that the woman claiming to be the key witness in the upcoming Bryan Kohberger capital murder trial repeatedly asserted her role as a witness to at least 3 different officers. Now, this footage obtained through a public records request provides fresh insight into the high-profile case surrounding the 2022 stabbing deaths of the 4 University of Idaho students. And this development is significant as it underscores the potential testimony of a DoorDash driver who claims to have seen Kohberger near the crime scene, offering a rare direct link to the suspect in a largely circumstantial case. Now, the release of the footage has reignited public and legal interest in the trial, which is scheduled to begin on August 4th there in Boise, Idaho. Now, on September 4th of 2024, the woman was pulled over for driving with expired registration and was subsequently arrested for allegedly driving under the influence. Now, during the stop and while in custody, she repeatedly told officers that she was the DoorDash driver who delivered food to Xander Kernodle on one of the 4 victims in the early morning hours of November 13th of 2022, just minutes before the killings occurred. Now, in the footage, the woman, visibly emotional, stated 4 times to 3 different officers that she was set to testify against Bryan in the trial. "I've got to testify against Bryan next year. I've got enough crap going on," she told one officer while handcuffed in the police car. She later reiterated, "I'm supposed to testify against Bryan next year," referring to the guy that killed all the girls over in Moscow. The Pullman police holding facility, she told a 3rd officer, "Now I have to testify in that big murder case here because I'm the DoorDash driver," clarifying that she saw Kohberger at the scene and parked next to him. Now, the woman's DUI charge was later amended to first-degree negligent driving, to which she pled guilty. She has not responded to, as far as we know, any public comment. But, obviously, the significance of the testimony comes that Kohberger is obviously charged with the 4 counts of first-degree murder and 1 count of burglary in the deaths of Kernodle, Kaylee Gonzalez, Madison Mogan, and Ethan Chapin, who were stabbed to death in the off-campus home there in Moscow, Idaho. And prosecutors have indicated that the DoorDash driver's testimony will help establish a timeline of events and corroborate other witnesses' accounts. Now, the driver's claim of seeing Kohberger near the crime scene could be huge, pivotal, as she may be one of the only 2 living witnesses, alongside a surviving roommate who reported seeing a masked intruder with bushy eyebrows able to place somebody at the scene that night. Now, the case against Kohberger, let's not sugarcoat it, relies heavily on circumstantial evidence, making the driver's testimony potentially critical. And Kohberger's defense maintains his innocence, obviously, asserting that he was driving alone at the time of the killings. But obviously the significance for him at the trial is if he's convicted, well, he faces the death penalty. So the release of this new police footage is newsworthy because it provides the first public confirmation of the DoorDash driver's repeated claims about her role in the Kohberger trial, captured in the context obviously unrelated to the murder case. Now, the videos also offer a glimpse into the emotional weight the witness carries and highlights her consistent narrative across multiple interactions with law enforcement. And as the trial approaches, this footage amplifies the significance of her potential testimony, which could help prosecutors build their case against Kohberger in a trial that obviously has gripped just about everybody's attention. So the trial is scheduled to begin on August 4th with opening arguments scheduled for August 11th. The case continues to draw obviously intense scrutiny as the legal teams prepare for this complex and highly publicized case. It's going to be interesting, ladies and gentlemen. Now, obviously, this unidentified witness, since we don't necessarily know her name, but it is significant because if she says, I saw this car and I saw this person who I believe to fit the description of, or maybe a possible even identification of Bryan Kohberger, that could be a significant direct witness versus circumstantial evidence against Bryan Kohberger. That's obviously big for the prosecution. Now, obviously, if this person's been arrested, it could be ripe for cross-examination. Well, are you sure? Are you sure you weren't intoxicated that night? Right? Now, the defense is going to be very limited because it's not a felony conviction that they can bring in and say, oh, you have a felony conviction. You're not a trustworthy person. Probably it would be excluded of any police contact on a misdemeanor, basically a traffic offense. So it's going to be interesting. I'm sure the defense has dug up whatever they can and probably tried to speak with anybody else that she has tried to say, hey, I just happen to be this witness in this big case against Bryan. You know, it doesn't seem like she is searching for her 15 minutes of fame. Frankly, well, she got arrested. Not good. Anyway, we'll see. You know, woman's out there hustling, but you know, they're going to bring up all the stuff about it being dark. You were tired. You didn't see much. You can't say it was him directly. We're going to have to wait and see, obviously, for trial, because there were no motions to suppress the ID, because frankly, there was no government action at that point. So there would be no motion to suppress the identification. It's simply a question of fact for the jury to decide and give the testimony whatever weight they believe that it requires. Next on the docket is the Sean Combs case crumbling. That's right. Prosecutors in Sean Combs' ongoing criminal trial have dropped several key charges against Combs. And those charges include kidnapping, attempted arson, as well as aiding and abetting sex trafficking. The prosecution had to explain to the judge the decision in a filing, basically abiding by his suggestion to streamline the jury instructions. Now, this move comes as the closing arguments will begin more than likely tomorrow. Now, prosecutors have struggled to prove the kidnapping charge, which related to the testimony of Diddy's former employee, Capricorn Clark. She had alleged that she was kidnapped after some of Diddy's jewelry went missing. The arson charge stems from the allegation that Diddy blew up Kid Cudi's car in retaliation for his relationship with Cassie. And prosecutors were really never able to link him to the fire directly. The two charges were originally connected to the broader racketeering charge that obviously Combs faced. And while they've dropped the aiding and abetting and sex trafficking charge, prosecutors are still pursuing the other various sex trafficking charges in the indictment. Now, in the letters to the court, they note that just because an alleged victim gave consent to prior sexual acts, it doesn't mean that consent can't later be withdrawn. Additionally, they note that the financial compensation doesn't preclude a finding of forced labor. Sean Combs' legal team rested their case in his sex trafficking case on Tuesday after making arguments for only about 20 minutes. Their short presentation followed nearly 7 weeks of arguments and witness testimony brought by the prosecution there in New York, and the prosecution finished making their case Tuesday afternoon. Now, Combs' defense attorneys argued in their motion for judgment of acquittal that the government has failed to meet the burden of proving any of the charges against him, which he vehemently denies, and the judge should stop the case from going forward. Sean Combs confirmed to the court that he would not take the stand at his own trial. He said, quote, "It is my decision with my lawyers not to testify," end quote, is what he told the judge. Now, Mr. Combs has pled not guilty to charges of sex trafficking, racketeering, and transportation to engage in prostitution. Obviously, he could face a maximum life sentence in prison if he was convicted. Now, speaking for the first time in court, Mr. Combs also told the judge, "You're doing an excellent job. I want to tell you, thank you." This all took place during that colloquy to see whether he was going to testify or not. Now, prosecutors have obviously alleged that Mr. Combs used his celebrity status and business empire to run a criminal enterprise to sex traffic women and conceal his crimes. And during their arguments, the government called more than 30 witnesses to the stand. The defense called none, instead submitting into evidence several text messages between Mr. Combs and his ex-girlfriend, singer Cassandra Ventura, and other victims who testified under the pseudonym of Jane. Now, it was always difficult for the defense teams to decide whether to call any fact witnesses to the stand. I'm a firm believer less is more, and you only call them if you absolutely positively have to, because frankly, so much can go wrong. And calling new witnesses obviously can produce more problems for the defense, and having Mr. Combs take the stand would have been an even riskier move, hanging the case mostly upon his testimony, where jurors stop focusing on the evidence or the lack thereof, and whether they believe Mr. Combs on the witness stand. Anyway, Mr. Combs' lawyers gave a quick presentation showing messages in an attempt to bolster their argument that Mr. Combs' girlfriends were willing participants in sexual encounters with him, as well as with the male escorts that were ultimately called freak-offs. In one message to Mr. Combs that his attorneys read aloud, James told him, "I always have fun during those freak-offs," or what she called hotel nights. The quick defense case came after Mr. Combs' legal team filed a motion obviously asking the court to acquit him, i.e. motion for judgment of acquittal, denied. Anyway, his attorneys argued that the victims in the case were capable women who could have left on their own accord had they done to do so. Obviously, giving a hint to the points the legal team is going to raise during closing arguments, which is scheduled for this week on Thursday and Friday. They did also somewhat note that Mr. Combs was regrettably violent. But guess what? Domestic violence is not sex trafficking. And prosecutors have argued that Mr. Combs' ex-girlfriends were coerced into unwanted sex acts with drugs, violence, and other means. The defense has denied those allegations. And when I mean the case is falling apart, you know, when you read the indictment, you're like, oh, this is not good. This is not good. But as the evidence has been presented in this particular case, it's not exactly the criminal enterprise that one would imagine in a human sex trafficking thing. Okay. I know I've defended sex trafficking cases, and, normally it's, they bring in prostitutes or underage people and they testify as to their experience. But normally, do they never have text messages saying, oh, this is all great? And if they do, of course, they say, well, yes, but now that I've been in contact with my therapist, I understand that I was abused and I was coerced and blah, blah, blah. But at the time, they're all willing participants. Now, of course, prostitution is illegal, and so you can't do that. Obviously, the defense is going to get up and say, this was all fun and games until it wasn't, until their relationship broke up and Mr. Combs stopped paying everybody's bills, right? It's always about the money, ladies and gentlemen. Bottom line, does Mr. Combs seem like a perfect citizen? No, clearly got some sexual issues he may want to deal with when this gets resolved. Do I see this as a huge criminal enterprise? No, seems like a spoiled rich guy that thinks he can get away with what he wants, and he acts a tough guy when everybody's doing it. And then, of course, he goes off into his, quarters with his little private sex acts and does what he does just because he likes a lot of lube and lotion and likes to bring a lot of people to the party, not necessarily criminal conduct. Now, he's got a lot of charges. Something could stick. I don't know. But if I was his defense attorneys, I'd feel like I am with any case where I have going to the jury. They got a shot. That's right. They got a shot. We'll see. We'll see how it goes. Next, the defense challenges the prosecution in the Mangoni case. That's right. They're not happy. So in letters addressed to the judge there in New York Supreme Court, the defense team for Luigi Mangoni, charged in the indictment, has raised serious objections to the prosecution's conduct in the high-profile case. Now, the defense's reply, submitted in support of an omnibus motion, outlines 4 primary concerns: the public release of Mangoni's alleged journal, unsupported terrorism charges, the scheduling of the state trial before a federal death penalty case, and the need for a motion scheduled to address procedural demands. So let's go through a quick summary of their key points and their implications. First, the public release of the alleged journal. The defense argues that the prosecution has prejudiced Mangoni's right to a fair trial by publicly releasing his alleged journal, described as a diary by the prosecution, but repeatedly referred to as a manifesto in their filings. Now, the defense contends that this release was unnecessary, as the journal is already a part of the grand jury evidence, and a MAP hearing to determine the legality of the search of Mangoni's backpack has been consented to. They assert that the selective release of potentially inadmissible material aims to bias public opinion against Mangoni, particularly significant given this his concurrent federal death penalty case. Now, the defense cites their local rule of the Southern and Eastern Districts of New York, which prohibits the release of prejudicial information likely to be inadmissible, emphasizing the rule's relevance to Mangoni's federal case. The next point they want to bring up is the unsubstantiated terrorism charge. Now, defense challenges the prosecution's terrorism-related charges, specifically murder in the first degree, as an act of terrorism, arguing they lack legal and factual grounding. They refute the prosecution's claim that Mangoni's alleged actions alone demonstrate terroristic intent, noting that alternative motives, such as targeting the victim for a specific action at the United Healthcare meeting, are plausible. The defense also disputes the prosecution's reliance on Mangoni's private journal entries, asserting that these reflect personal grievances rather than an intent to intimidate or coerce a civilian population, as the New York Penal Code requires. Now, they further argue that any public response, such as threats against insurance workers, stems from the prosecution's public disclosures rather than Mr. Mangoni's actions. The defense emphasizes that the terrorism charges require an intent to harm multiple individuals, citing various precedent, like the case of People v. Morales, and notes that the United States Attorney's Office did not charge Mangoni with terrorism, undermining the state's position as well. Their next point is that the state trial scheduling conflicts with the federal case. Now, the defense contends that the proceedings with the state trial before the federal death penalty case violates Mangoni's constitutional rights. They argue that the simultaneous prosecution for the same incident with differing charges and defenses burdens Mangoni, who must participate in his defense while managing extensive discovery, roughly about 9.7 terabytes according to the defense, and then obviously preparing for a complex federal case as well. Now, the defense highlights that no modern precedent exists for a non-capital state prosecution proceeding a federal death penalty case, and they compare the case's timeline to other New York murder cases, which took years to reach trial, and criticize the prosecution's push to accelerate the proceedings. Now, the defense also warns that testifying in the state case could prejudice Mangoni in the federal case, where his testimony could be used against him in the capital context, invoking the supremacy clause to prioritize federal protections. That's right. Remember, federal law trumps state law, supremacy clause. Interesting argument. Anyway, and fourth, the defense requests for motions scheduling. The defense requests the court set a motion schedule to address the prosecution's demand for notice under the local rules, which relates to psychiatric defenses. They argue that the prosecution's rush to expedite the case disregards the court's prior guidance and risks procedural errors, and the defense maintains that they will not yet serve their request notice to avoid prejudicing Mangoni's rights, particularly giving double jeopardy concerns raised by concurrent prosecutions. They cite to a case to argue that dual prosecutions for the same offense violates fairness principles, urging the court to establish a schedule that considers these constitutional issues. Interesting issue. Don't think that's going to float. Separate sovereign. They can charge you even if it's the same factual basis. I understand their frustration. It would make sense for the death penalty case to go forward, because then you can basically fall back on the state case if something goes wrong on appeals. But the feds wanted to go first because they get to see the state present their evidence. There must be some strategy to that, i.e., is Mangoni going to have to testify? It's basically a mess. But guess what? Somebody's got to go first. Death penalty case, obviously we've seen in the death penalty cases, they take much longer because of all the mitigation. Fortunately, though, his attorneys are the same, so they should be ready to go. But eventually, guess what? Some case is going to have to go first, and the judge will ultimately decide. Complicated issues, but it's not that complicated of a case, in all honesty. The prosecution has to prove identity, and guess what? The diary, the notebook, the manifesto, whatever you want to call it, did the prosecution have to publish that? They didn't. It's not like they released it to the press. It was in a filing made public to the court. That's how it was put out there. But that is the evidence in the case. And heck, the way things are going with Luigi Mangoni, it could help him with a jury in New York. Who knows? Who knows what's going to go on in New York, right? You never know. Anyway, the defense letter underscores obviously these tensions between the state and federal judicial process, particularly in cases involving severe penalties like, the death penalty. It raises questions about prosecutorial discretion in managing public information and the potential for prejudicing a defendant in a high-profile case. And the reference to prior threats against the United Healthcare CEO disclosed in the grand jury testimony suggests a broader context of public frustration with the insurance industry, which the defense argues the prosecution has exploited to bolster its case. Who likes insurance companies? Insurance companies are probably some of the most horrible corporations on earth. If you've ever dealt with an insurance company, right? They want your money. They want you to sign immediately. And then they don't want to cover claims, or they want to settle for minimal amounts of money. If you're talking about a jury nullification, my God, could this be the case? Possibly, because everybody hates insurance companies. And if they can make the CEO look like a real dirtbag, go to the jury nullification defense of that guy deserved killing. And I'm not saying he deserved killing. Nobody deserves to die like that, being shot in the back by allegedly Luigi Mangoni. But, juries are mysterious things. You never know what a jury will do. Literally, you never know what a jury may do. Anyway, the court's response to these arguments could set significant precedents for handling dual prosecutions, as well as protecting a defendant's fair trial rights in cases, obviously, where there's extensive media coverage. And obviously, Mangoni's defense team is pushing for a measured approach to ensure that their clients' constitutional protections are upheld amidst what they described as a prosecutorial overreach. So Lori Vallow let her grievances be known to the judge in a motion for a new trial. That's right. Lori Vallow, the defendant in the high-profile case of Vallow, Arizona v. Vallow, has filed a motion for a new trial alleging significant violations of her constitutional rights. The motion submitted on June 23rd to the Maricopa County Superior Court accuses the court of denying her a fair and impartial trial due to judicial misconduct and procedural errors. Now, Ms. Vallow, who's been representing herself, asserts that the Fourth Amendment rights were breached when the court compelled her to proceed with trial despite severe illness. She probably means her 14th Amendment rights, but let's go with what she wrote. Anyway, the court records show that she suffered from vomiting and a viral infection confirmed by medical evaluators, but the court ordered her to go to court by any means necessary from May 30th to June 12th, and she informed the judge and the state of her condition, yet was required to continue a decision that she labels as a denial of due process under the 5th and 14th Amendments of the United States Constitution, Article 2, Section 4 of the Arizona Constitution as well. Further, Ms. Vallow claims that the court exhibited a lack of impartiality by restricting her ability to present her defense. She was denied opportunities to argue objections, consult with her investigator, and cross-examine witnesses effectively. Now, these specific grievances include the court's refusal to allow questioning of initial responding officers and sustaining of hearsay objections without permitting her response during cross-examination. The motion also highlights an abuse of discretion by the court, according to Ms. Vallow. Anyway, Ms. Vallow alleged that she was denied a Rule 13.5 hearing on aggravating factors despite only one sentence being applicable for the charged crime of conspiracy to commit first-degree murder. Additionally, the court failed to formally release the jury on the record after the verdict on June 12th and allowed forensic evidence without sufficient foundation, notably from analysts relying on work by a witness by the name of Tammy Lacknick, whose later disclosed resignation due to an incident was not fully investigated. This, she argues, violated her Sixth Amendment right to confront and cross-examine witnesses. In conclusion, Ms. Vallow contends that the state of Arizona has failed to uphold her constitutional rights, warranting a new trial. The case, which concluded with a verdict on June 12th, obviously where she was found guilty. The court has yet to respond to the filings, but let me guess. Do I even need the magic 8-ball? Will Lori Vallow's motion for new trial be denied? Signs point to yes. There you go, ladies and gentlemen. Denied. Now, some jurisdictions require you to file a motion for a new trial to present and preserve legal errors. Most jurisdictions have abandoned that. You don't have to file a motion for a new trial to preserve those appellate rights. This could have been saved on appeal. Let's face it, it's not like she's going anywhere. She's pro se defendant. She's got plenty of time. Let's throw it out there. And apparently she thinks that maybe the judge that has denied every single motion and has denied every request that she's ever made is somehow going to have a change of heart and say, you know what? I didn't give you a fair trial. Let's do it over again. What are the odds of that happening? Zip, zilch, zero, nada, nothing, none. No chance. Next, Karmelo Anthony, indicted as an adult on April 2nd of this year. At a high school stadium in Frisco, Texas, 17-year-old Austin Metcalf was fatally stabbed by 17-year-old Karmelo Anthony during a track meet. Now, this incident occurred after Metcalf asked Anthony, who attended a different school, to leave his team's tent. Anthony, now 18, claimed self-defense, but was indicted on first-degree murder charges by a grand jury on the 24th of this month. But here's where it gets interesting. Video footage from the stadium camera allegedly shows no visible altercation or escalation prior to the stabbing, which obviously potentially undermines Mr. Anthony's self-defense claim now, doesn't it? Anyway, the Frisco Police Department had initially charged Anthony with first-degree murder, and then the local district attorney presented evidence to the grand jury to uphold this charge. Now, Anthony, who has been in jail for nearly 2 weeks before being released on bond to a house arrest, learned of the indictment shortly before this announcement by the prosecutor. We'll see if the bond isn't increased as well, but we'll see. Obviously, that video could play a key part. Remember, for there to be self-defense, you have to have an immediate fear, imminent fear of death or serious bodily injury, not just disrespected. Tragedy. We got a dead 17-year-old who died in the arms of his twin brother, and we have a young man who obviously now faces going to prison for the rest of his life over some sort of unknown altercation or simply being asked to go to a different school's tent since you don't go to this school. I don't know. It kind of seems like a reasonable request, but certainly not anything that anybody should die over. we'll obviously be following that case as it progresses. Next, federal prosecutors get a guilty plea on a hate crime charge. Let's go to Pennsylvania. A 58-year-old man faces up to life behind bars for shooting 2 Latino men in what prosecutors called a hate crime. Now, the U.S. Department of Justice announced that Douglas Cornett pled guilty on June 18th to 2 federal hate crimes charged involving attempt to kill and discharge a firearm during a federal crime of violence. Now, Cornett is scheduled for sentencing on November 13th and faces a mandatory 10-year sentence for the firearms violation and a maximum of life imprisonment for the hate crimes. Now, according to the press release from the sheriff's office on the night of February 28th of 2024, deputies responded to a report of a shooting. Detectives reportedly located 2 Latino victims suffering from multiple gunshot wounds, and they were transported to the local hospital trauma center for their injuries. Upon further investigation, authorities reportedly learned that Cornett followed a box truck driven by one of the victims, identified with the initials OG, into a gas station. Prosecutors then alleged that Cornett asked the other victim, JM, how long OG had been in the United States. Cornett reportedly learned OG arrived in the United States within the last 2 years and then shot him 3 times and then shot JM once. According to the prosecutors, Cornett later confessed to the sheriff for shooting the victims because of his perception of their national origin. Anyway, the United States attorneys say that hate crimes driven by bias against national origin or any other protected characteristic are a direct assault on the principles of equality and justice that define our nation. The United States attorney added that crimes like Douglas Cornett's acts of hate, motivated violence victimize not just the individual, but harm families, communities, and groups by robbing them of their sense of security. Completely senseless crime. Unbelievable. Minimum 10 to life seems more than reasonable. Somehow I think it's going to be more than the minimum 10 in federal court. Ridiculous. Senseless. Nonsensical violence. Next on the docket, this day in legal history. On June 25th, 1798, the United States Congress passed the Alien and Sedition Act of 1798, which empowered the president to deport any alien he found dangerous to the peace and safety of the nation. Now, in 1798, the United States stood on the brink of a war with France. The Federalist Party, which advocated for a strong central government, believed that the Democrat/Republican criticism of the Federalist policies was disloyal and feared that aliens or non-citizens living in the United States would sympathize with the French during the war. As a result, the Federalists, obviously a political party no longer around, controlled Congress, passed 4 laws known collectively as the Alien and Sedition Acts. These laws raised the residency requirement of citizenship from 5 to 14 years, authorized the president to deport aliens and permitted their arrest, imprisonment, and deportation during wartime. And the Sedition Act made it a crime for American citizens to print, utter, or publish any false, scandalous, and malicious writings about the government. Completely violation of the First Amendment, I might note. Anyway, the Alien and Sedition Acts of 1798 are no longer in effect, and these 4 laws passed by the Federalist-controlled U.S. Congress were enacted during a period of tension with France and aimed to strengthen national security and suppress political opposition. Like I said, they included the Naturalization Act, extended the residency requirements. The Alien Act allowed the president to deport non-citizens deemed dangerous. The Alien Enemies Act permitted the president to apprehend, restrain, or remove male citizens of a foreign nation during times of declared war. And the Sedition Act criminalized making false statements that were critical of the federal government. So like I said, this expired. The Naturalization Act was repealed in 1802, and the Alien Act and Sedition Act expired by their own terms in 1800 and in 1801, respectively. Now, the Aliens Enemy Act, however, was not repealed and remains on the books, though it's limited to wartime use. And then, of course, we have some current relevance. The Alien Enemies Act, codified at 50 United States Code Section 21 through 24, is technically still in effect, but applies only during a declared war, allowing the president to detain or deport citizens of an enemy nation. And it was notably used during World War II to intern Japanese, German, and Italian nationals. The other 3 acts obviously are no longer in force. Next, this day in legal history. On June 25th, 1910, Congress passed the Mann Act, prohibiting the interstate transport of women for immoral purposes, intended to combat human trafficking. Yes, ladies and gentlemen, even in 1910, still, the Mann Act, human trafficking. What do I keep telling you? Everything we talk about, the law stays the same. It's the same issues. They just repackage it every 20 years. And because the same issues rise up. Maybe it's 20 years, 100 years. It's all the same stuff. Then on June 25th, 1938, Benjamin Bugsy Siegel was noted in FBI records for consolidating his organized crime operations in Las Vegas, influencing later federal anti-racketeering efforts under the RICO Act. On June 25th, 1948, Congress enacted 18 United States Code 1111, defining federal murder in the first and second degrees, establishing penalties including death or life in prison for first-degree murder. And then on June 25th, 1990, preliminary legal arguments in lower courts for what became Dickerson versus United States, decided in 2000, were noted, reinforcing Miranda rights against attempts to weaken them. And then on June 25th, 1997, the United States Supreme Court struck down the parts of the Communications Decency Act in Reno v. ACLU, protecting online free speech and obviously shaping legal frameworks for the internet-related crimes. And June 25th, 2012, the United States Supreme Court ruled in Miller v. Alabama that mandatory life sentences without parole for juveniles violates the Eighth Amendment, reshaping juvenile justice policies. What does that mean? If you were convicted of murder and you got life without parole as a juvenile, you are now eligible for parole after 40 years. And then on June 25th, 2023, the United States Supreme Court ruled in Counterman v. Colorado that true threats require proof of the defendant's intent, refining First Amendment protections and criminal threat prosecutions. This case, Colorado, very familiar with true threats, case law, just saying, we made that argument before they made that argument. Just saying. All right, our legal quote of the day. Freedom of speech is the bedrock of a free society, for it allows the truth to emerge through the clash of ideas, no matter how uncomfortable or unpopular they may be. John Stuart Mill. We talk about that all the time, ladies and gentlemen. There's so many people that want to just completely shut out what the other party's argument is. I don't care if you're talking politics or you're talking a case. If you disagree somehow, well, you're not in my tribe anymore. We can't talk. Listen, if both arguments are presented, you're either going to say, yes, you're reinforcing my idea that I am correct because your ideas fail under cross-examination, or the person's going to say, you know what? Maybe I hadn't thought of that. Maybe I'm right there. That's a good point. Maybe my argument isn't as strong on that particular point or not. But if you just completely dismiss the arguments, the ones you don't like, I don't know. I don't understand that. Free speech is what makes us better. It makes us better. It makes us a better society. Free flow of information. It may even be things that you don't like. You know, go to parts of the world where you can't speak your mind, or you say it and somebody comes and picks you up in the middle of the night. Ladies and gentlemen, we've got it pretty darn good. Now, you can't say, libelous and slanderous things about other people, and you can't make true threats. There's a limit to that free speech. But, if somebody wanted to say the world is flat, let them explain why they think the world is flat. And then you can present your argument as to why the world is not flat. And who knows, maybe you'll change your mind. Or maybe they'll say, nope, I'm even more convinced that the world is flat. Sometimes that's not a bad thing. Next on the docket, our dumb criminal of the day. And the Dumb Criminal of the Day award goes to Charles Dalzell. In a crowded field of contenders vying for the prestigious Dumb Criminal of the Day title, North Dakota's Charles Dalzell has clinched the crown with a performance so audacious, dim-witted, it deserves a standing ovation from the galaxy's finest knuckleheads. On Sunday, Dalzell decided to channel his inner keyboard warrior, firing off a threatening email to the United States Attorney's Office in North Dakota, referencing the recent assassination of Minnesota state lawmaker Melissa Hortman and her husband, ominously typed, "I don't want this situation to end up like Minnesota over the weekend," subtle as a sledgehammer. Anyway, apparently he thought this was the perfect way to express his frustration over some mysterious court-awarded money he claims he owed, no record of which exists, mind you. But here's where Daybell truly shines. After lobbying this not-so-veiled threat, implying he or someone else might go full Minnesota if ignored, he sashayed over to retrieve his confiscated firearm. Yes, you heard that right. The man just emailed a federal official with a nod to a double assassination thought. You know what? Now's not a great time to pick up my gun. Spoiler alert, it wasn't. Not content with one email, Daybell doubled down on Monday, sending another missive that trashed North Dakota's officials, including Governor Kelly Armstrong. And because nothing says "I'm stable genius" like poking the bear twice, authorities unsurprisingly scooped him up later that day, and now he's cooling his heels in custody, probably wondering where it all went wrong. The competition was fierce. We had contenders like the guy who tried to rob a bank with a carrot and another who live streamed his own getaway. But Daybell's combo of threatening a federal official referencing a high-profile crime and then waltzing in to grab his gun like a library book takes the cake. Congratulations, Charles. You're the dimmest star in today's criminal constellation. Congratulations. You made it. All right, ladies and gentlemen, that's all we have for today. Hope you enjoyed the show. Join us tomorrow. We'll see you next time. And remember, Constitution matters.